Welcome to What's the Scenario with PLRB, where we explore claims and coverage scenarios relevant to insurance professionals. I'm Brendan McLaughlin.
I'm Mike Rode.
I'm Tim Heffler.
And as promised, I said I would return because we got a phone call. I'm Michele Hunter, Coverage Counsel at PLRB.
Yay.
Welcome back, Michele. So, Michele, what's the scenario?
The scenario today is that a concert attendee filed a lawsuit against a band's lead singer and two businesses that were affiliated with the singer. So these are all of the insureds, based on the singer's alleged onslaught of blows to the attendee's face, head, and body over a dispute. However, despite the lawsuit, this singer's version of events is completely different. According to the singer, he claimed that the confrontation only became violent when the attendee threw the first punch. And so he's basically claiming, the singer, that he was defending himself and that security guards had to intervene before any punches really landed. So the singer ended up tendering the suit to his insurer, who agreed to defend under a reservation of rights. But the real question is there a duty to defend?
The last concert you went to, what band did you see?
An 80s band, Aura.
Who?
Aura. It's a cover band for 80s music.
Oh. What kind of 80s music?
Like pop
heavy metal?
80s music. Yeah. All the favorites. You know, the best era of music, the best decade ever.
I'm with you. I'm in the 80s.
I'm more of a
about you?
90s kid.
Okay.
I like
For me, it was a long time ago. I'm sure it was pre-COVID. I believe it was Summerfest in Milwaukee.
Ooh.
I think the headliner was Tom Petty and the Heartbreakers.
Oh, wow. It is because Tom Petty's no longer with us, so that was a while ago.
Yeah, right. Well, he's kind of 80s and 90s and 70s. What kind of concert was going on here with hypothetical? Was this a rock concert?
Yeah, rock concert. Punch Drunk Love, let's say, was the song.
Oh, I like that.
Yeah, happened. Or didn't it? Depends on whose version of events that we go with.
You're here.
Mm-hmm.
So help me out a little bit, Michele. There's, I think I know, based on a prior life, that our duty to defend is usually a little more generous than our duty to provide coverage under the policy. So even though there's some allegation that there might have been what appears to be like an intentional act when you're throwing punches, that usually isn't an accident like we talked about last time. So this isn't really an occurrence. So
Right.
how do you sneak through coverage for defense here with these types of cases?
Again, a very good question, Mike.
Thank you.
And that is exactly what this is a real case I'm talking about, as a matter of fact. It's a California federal district court case. And in that case, the insurer argued exactly what you're saying. Listen, all the conduct that's alleged is intentional.
Right.
And we can see that based on what they call either the four corners or eight corners of the complaint. Now, I'll just explain that concept really quick before we move forward. Four corners or eight corners is basically the same thing as saying, hey, we're only going to look at the complaint, those four corners. And when they say eight corners, what they mean is we're only looking at the complaint and we're only looking at the insurance policy. So it's really two different ways of saying the same thing. But if we look only to the complaint, which alleged intentional conduct by the part of that insured singer, the insurance company had a strong argument to say, listen, in a CGL policy, we have an intentional acts exclusion. That would clearly apply here. There's nothing alleged that isn't intentional, and therefore we don't have a duty to defend. But guess what the court said?
What?
And again, it's a U.S. District Court case in California. And what the court said is that what the insurer said raised factual questions of whether the attendee, the person filing the lawsuit, whether those claims arose from an accident. That depended on whether the insured intended to strike the attendee or whether the insured singer struck him accidentally while defending himself, or attempting to keep that attendee away from the rest of the crowd.
There you go. And I had
So
another
you can,
question too, Michelle. There before
yeah,
I'm sorry to interrupt you, but yeah, I
yeah,
just remembered too that to the exclusion there on intentional
yeah.
or expected act. Yeah, isn't there a I don't want to call it a buyback, but there's wording there that says, "Hey, this doesn't apply if you did it in self-defense."
Yes, that is 100% right too. And again, that gets to the actual allegations in the complaint. And I would imagine the court, they didn't say that, but I would imagine the court would take that into consideration because basically, you're right. It does restore coverage if it was in self defense. And again, that's a factual issue, right? And so, based on such conflicting versions of events, and that broad duty to defend, as you mentioned, the court was basically what they said is that when there are facts extrinsic to the complaint that are gathered from the insured or other sources, then that it's an incorrect assumption to think that only the allegations matter and there will be a duty to defend.
So, Michelle, I got a question too.
Yeah.
Could the attorney have drafted the complaint a little bit differently? So maybe the allegations weren't so much reminiscent of intentional conduct, but sounding more in negligence type of conduct. Would that do courts let that happen? Does that
hmm
expand what
That's a
can be
that's a
following
great
duty?
question. Courts really vary on that issue because there are a lot of courts and case law saying you cannot garner a duty to defend or coverage just by pleading negligence if it doesn't make any sense based on the facts. So you can't creatively plead essentially to get a duty to defend, but most complaints do plead in the alternative like that, negligence and intentional conduct in a way to try to, garner a duty to defend or obligate some sort of duty on the part of the insurer? So that's a great question. And typically that's what does happen, Tim. So yes, I mean, I think they increase their odds in every way by pleading to, obviously make the insurer defend.
Increase their odds. That's a good way to put it. But so the attorney in this claim didn't do that. They just put
Mm-mm.
intentional.
It was intentional.
Got it. But the court still found a way to
Yep.
duty. Okay.
And it did actually, now that I say about, I think it did, the court did get into self-defense a little bit. And so I think, it always makes sense to probably plead in the alternative, and that's most common. That's what I see a lot. So I think that, yeah, to your point, self-defense is restoring coverage, like Mike said, or could, and it's a factual question. And with these conflicting versions of events, then they're going to find a duty to defend typically. So let's say different courts. What this is called is extrinsic evidence. By the way, it's extrinsic evidence is exception to the four corners or eight corners rule. So as we know, for any insurance law or rule, there's always going to be an exception, right? And so different courts in different states treat, as we probably are not surprised, extrinsic evidence differently. And so you want to know what state you're in when you're handling a case like this. And one state in particular, for example, Texas, they actually developed a test for when you apply extrinsic evidence. And what they said is that if the extrinsic evidence goes solely to the issue of coverage and does not contradict the facts in the complaint, then it should be allowed. Now, look at our initial coverage scenario. Were the extrinsic facts opposite the complaint?
Well, yeah, because the singer was directly contradicting the claims of the attendee, right?
Oh,
Right,
Saying it didn't happen like that at all.
right.
Um,
Completely the opposite.
yeah.
So under Texas law, I mean, you'd make a good argument that, listen, this is completely in contradiction to the facts alleged in the complaint, and therefore it is not admissible as extrinsic evidence. Now, what if we flip the scenario a little bit and I'll take a poll on this? Let's see. What is the insurer allowed to rely on extrinsic evidence? Because in our initial scenario, it was the insured alleging extrinsic evidence. Can an insurer allege extrinsic evidence in order to relieve itself of the obligation to defend?
I'm going to vote no. They're
I'll
totally
say
outside the whole scenario here. They're an insurance company. They had nothing to do with this claim. No way they can throw stuff.
Okay, Mike's
I'll
answer is no.
say yes, just to
Oh,
oppose Mike mostly, but if the insurance company wants to conduct an investigation and they find some things out, let's talk about it.
oh, oh.
I will say yes, but only to contradict other other extrinsic evidence.
Oh.
Okay, so again, another trick question. The answer is maybe, depends on the state.
Oh,
And I know that's not, so everybody's right. We
We're
can
right.
take that away.
Yay.
Everybody's right. Everybody gets a badge. Bottom line is, there are cases like in Florida that say you cannot do that. But then there are other cases, like, for example, in, basically in Hawaii, in New York, other states allow it. And in, for example, there's cases out there, if an exclusion clearly applies, like a pollution exclusion, or in one case it was a trampoline exclusion, believe it or not. And the complaint did not say it was a trampoline. And the insurer came back and said all the evidence and all the facts regarding this claim are that it happened on a trampoline. And this policy clearly has a trampoline exclusion or a pollution exclusion. So in those cases, the insurer was actually allowed to claim those exclusions as extrinsic evidence to defeat a duty to defend.
You
It's
know,
kind of interesting.
yeah, I feel like a part of this, I'm wondering if a part of this has to do with kind of complexity, because I feel like probably a lot of the point of the four corners or eight corners rule is to kind of make it quick and clear. We're skipping over a bunch of this stuff so we can skip straight to, we got the party defended, let's get this figured out. But when you start bringing in extrinsic evidence, it can get really complicated to figure all that out, right?
Right.
So is there a consideration of, what is this evidence and how difficult is it going to be to parse out the truth of what's going on? Is that
Right.
part of the consideration?
That it is, and that's a lot of times where insurers will file declaratory judgments to determine is there a duty to defend. But then that's like a mini trial in and of itself, as we know. And so to avoid that, sometimes they'll just say no, this exclusion applies, and they'll just risk being sued for bad faith by the insured, or because they feel that confident that, hey, like the trampoline scenario, and that paid off for the insurer because it was like, just because they didn't allege it happened on a trampoline doesn't mean it didn't happen on a trampoline. And when you have an exclusion that clearly applies to a trampoline, then, end of story. Now, do you think there's a state out there that says an insurer has to look to the allegation beyond the complaint?
Of course
Like,
there is. We got 50 out there to choose from. So one of them at least has got to say yes, they can do that.
Mike's playing the odds.
Anybody want to guess which state?
California.
That is a very good guess, but wrong. There's
Wait a minute, Michele. Don't give it up yet, Brennan.
Okay.
Name a state.
I was trying to think of the most contrary state. Rhode Island?
Ooh. So I'm
Nope.
going with Oregon.
Oh, all right. Unfortunately, everybody failed this one. I mean, 3 guesses out of 50.
Our odds
The
weren't
odds were
great.
not with you.
Right.
That's okay. It's South Carolina.
Oh, wow. Oh.
Yeah. Very surprising. Okay, here's another question.
Ooh.
Have you ever seen an endorsement in an insurance policy, the CGL policy for purposes of our scenario, that allows the insurer to look at extrinsic evidence?
I have never seen such a thing.
Nor have I, although I have not looked through many CGL policies in my life.
Mm-hmm.
And I wonder if that would be upheld. Yeah, that's interesting.
Mm-hmm. And that's exactly the issue. It was a Washington court case. And was that enforceable? And unfortunately, we're still all on the edge of our seat for that one because the court decided the case on different issues and never got to that issue and did not decide it. But that's an interesting policy provision. And one that I am not seeing in a policy, but it's obviously a way for an insurer to say, hey, I want to contract my way to consider extrinsic evidence.
Very interesting.
Mm-hmm.
If that ever gets decided, Michele, we have to have you back then so we can talk about it.
Exactly.
I think we need to have Michele back to talk about the person who got stabbed on a trampoline. I want to hear about that one.
Yeah, no.
There we go. There we go. Okay. One last question.
Ooh.
All right. Do you think that extrinsic evidence could ever create a duty to defend?
I'm going to go with yes.
I've noticed a pattern here. I'm going to go with depends on the state.
I feel like if it can come in to dispute that, it should be able to come in to go the other way. So,
So there's a California case, and this is all in our database. But yes, that's what the court held, is actually extrinsic evidence created a duty to defend. And so that is all very interesting when it comes to extrinsic evidence.
All right. So, Michele, what can we take away from this scenario?
I'd say we could take away the fact that anytime we have a rule, like 4 corners or 8 corners, you can believe there's going to be an exception out there. And in this case, it's extrinsic evidence. And what's really important is to know the state you're in and how it treats extrinsic evidence. Is there a test on it? Is there case law on it? Are they open and shut? And does a policy contain an endorsement or a policy provision allowing it? There's all these questions. And so you just want to know the state you're in, the actual allegations pled, and then basically that, extrinsic evidence can be a game changer at the end of the day.
And Mike, when someone goes to our fabulous website, PLRB.org, are you aware of any resources on this topic they might search for?
I am aware of a few, and one would be under the policy annotations for the GL policy. I believe, and Chuck, correct me if I'm wrong, this would be under GL 37, which talks about the admissibility of extrinsic, easy for me to say, evidence regarding an insurer's duty to defend. So we got that. We have some cool stuff on the expected or intended injury exclusion. Different states will look at that. Also, for the annotated keys of our GL policy, that would be GL 71, if you want to look it up on your paper. And there's also a cool law review California Federal District case out there that we're going to share, I think, Brennan, that link in the show notes, so I don't have to read the long site where we get that from, but you'll add it to the show notes, right, Brennan?
Yes, and there you'll also find a recap of the key points from the episode and links to our social media. Don't forget to subscribe and rate us, and please give us a call at 630-509-8704 and leave a voicemail to share your adjuster story. We'll see you next time.
No. Have we had a phone call yet?
Not yet.
All right. Darn it. All right. Next time.
Yes, my future attendance is conditioned upon this phone call.
Right. Somebody needs to make one. You want Michele back? Vote with your phone call.
Right, please.
Yeah. Let's make it happen. 630-509-8704.
Awesome.
All right. See you next time.
Everybody.
Right. Thanks for having me.
The views and opinions expressed in this resource are those of the individual speaker and not necessarily those of the Property and Liability Resource Bureau, its membership, or any organization with which the presenter is employed or affiliated. The information, ideas, and opinions are presented as information only and not as legal advice or offers of representation. Individual policy language and state laws vary, and listeners should rely on guidance from their companies